in the courtroom. With that, we are prepared to go forward. Mr. Donovan, you're representing the appellant. You may proceed.
Thank you.
I'm sorry, Mr. Lee, I see you're also here. I need to ask Ms. Degnan and Mr. Lee, are you all splitting the time at all?
Your Honor, if I may answer that, it's part of my points of order. Mr. Lee represents Ms. Gass, who was the plaintiff below, and I believe that the court had realigned Ms. Gass as an appellant. So the first point of order is that I'll be taking the lead on the appellant's position, both Ms. Gass's as well as the city's. If there's a question that is particular to Ms. Gass, then at that time I will reserve time towards the end of my argument, or if the court would prefer to use the style of the technology is, we could just even let him answer at the time, since we're all sort of around a digital table here.
Mr. Donovan, so my docket just didn't reflect what we all know, which is that Gass has been realigned as an appellant. So I guess I'm not sure I understood your answer. Are the two of you splitting the 20 minutes?
The answer is no, Your Honor, at least as of right now. If a question is posed that directly relates to Ms. Gass, I then would ask at that time to defer the question to him and reserve. But as of right now, Ms. Gass has joined in with the city for the most part on all of the arguments. So we worked it out that I would take the lead.
Very good. Mr. Lee, you're confirming that as well?
Yes, Your Honor.
Very good. Then Mr. Donovan, my apologies for the confusion. You may proceed.
Thank you. May it please the court, as Your Honor already acknowledged, Chris Donovan here on behalf of the appellant City of Naples. Before I delve into my argument, well, there were 4, but now I have 3 points of order. The first one is I would like to reserve 5 minutes for rebuttal. The second point of order is that this appeal has a little bit of an age on it. It was originally filed in 2019. I just want to make it clear for the court that we are under the old standard, even though the Supreme Court has changed the summary judgment standard. We're under the old summary judgment standard. And the fourth point of order, the third being that I'll be taking the lead. The fourth point of order is that I intend to stand on my brief with respects to Chops's challenge of the city's standing, unless it comes up during Chops's argument. Then I'll respond to it in rebuttal, because I think at this point, given the realignment and the fact that Chops cited Crowell versus Kaufman and 6 other cases that recognize a defendant who has been exonerated, the other co-defendant can appeal them. I think that it's pretty much academic at this point, but I'll rest on the brief for now. Instead, I would ask this court to reverse summary judgment for 3 reasons. First, Chops's evidence was not admissible or timely, the summary judgment evidence. Second, the summary judgment evidence also does not irrefutably prove that Chops owed no duty to Ms. Gass. And third, that summary judgment was premature because its discovery was outstanding and ongoing. So beginning at the top and the procedural errors that require reversal, Chops did not actually present any timely or admissible evidence. They actually presented 4 pieces of evidence: an aerial map, which was essentially a printout of the property appraiser's office, a lease, several photos, and the plaintiff's deposition. For the moment, I want to put the plaintiff's deposition in a basket over here. We'll address that in a minute, because it has its own little challenges. But the aerial map, the lease, and the photo, yes.
Mr. Donovan, let me ask a question as far as the filing of the documents, including the lease, or the failure to authenticate those filed documents. You had argued that the city could rely on the lease as an admission. So once you present that to the trial court, is the trial court to ignore the rest of the lease that is not favorable to your interpretation? Or is the court at that point invited to look at the whole lease?
Respectfully, Your Honor, yes and no is the answer to your question. We had preserved the argument the lease was inadmissible, period, because it was unauthenticated.
The argument was it's inadmissible because they didn't timely file it, but we can use it because it's an admission. I thought that was the argument that was made to the trial court.
Your Honor, I believe it was the lease and the map were timely, but they were not authentic. They were just attached to the motion.
Right.
which is, as this court recognized in Bryson versus BB&T, is not appropriate because it's hearsay.
We understand that point, but
Sure.
what I'm saying is, didn't you present to the trial court that the lease and the photographs have not timely been filed? But by the way, there's language in the lease that we can use because the appellee has demonstrated an adoption or an admission of that lease.
Yes, Your Honor, we did make that argument.
Okay,
but I
so
don't
stop
think
there. Once that argument is made, is the trial court entitled to look at the entire lease?
I don't believe so, Your Honor. I believe that the city was entitled to mitigate its damages, so to say, or mitigate it, the error of considering the lease in any way, and thus could use the lease against Chops Grill as an admission against interest. And that was the argument that was raised below. We certainly weren't waiving the objection to the fact that it wasn't authentic. But even if the lease was properly considered, the aerial photo, or excuse me, the aerial map was certainly not properly considered. And the aerial map is what Chops Grill essentially relied on record page 128 to try to say that, well, it's a public sidewalk. Just because it's a sidewalk doesn't mean it's a public sidewalk. They never actually presented any admissible evidence that it was a public sidewalk, much less that it was that the pavers on top of the sidewalk, which is the real issue in this case. That's the premises, so to say, that injured Miss Gass was the pavers on top of the sidewalk, and there was no evidence that Chops Grill did not install those or negligently maintain them, or that it didn't have a duty to maintain them.
Well, it's a little hard in this case without a transcript, because it's a little hard to believe that none of you referred to any of this evidence either in your favor or rebutted it or used it as a sword or a shield. There's no way we can tell what emphasis, if any, or what consideration, if any, the trial court gave it. You're telling me that it was an aerial map. Was it inaccurate, or you just didn't like it? I mean, she tripped over a paver. So how does an aerial map prejudice you? I mean, we don't have a transcript, which is astounding, to be quite honest with you. But
Your Honor,
we'll live with it. Go ahead.
Thank you, Your Honor. I agree that I wish we had a transcript. I was on trial counsel, and I wish we had a transcript, but we did recreate the record, what happened at the hearing through a stipulated order adopting.
I know, but your stipulation is internally inconsistent, because you say that the Chops attorney showed photographs which were addressed at the plaintiff's depot, which I assume someone from your firm was there, and attached them as exhibits. But then you say the city objected, arguing the photos were not the same. So are they the ones that were presented to the plaintiff or not?
Your Honor, it's my reading of it that it was that's what their argument was. Chops made that argument, and that we objected.
That's what you said in your agreed upon statement.
Yes, Your Honor, we're agreeing that they made that argument, and then we objected, that stating that the photos were not the same ones that were presented. I don't think that we were waiving the objection that we state in the second sentence to the fact that we agreed that they did make that argument. We just said that it's objected to. And but even if, sorry.
I still don't follow, because you're saying that they were addressed in the plaintiff's depot.
Your Honor, I'm pulling up the specific stipulation right now. It's my understanding, specifically, paragraph 6 says that specifically included in the arguments raised by Chops City's counsel during the hearing. So the preface of subsection A was that these are Chops Grill's arguments.
Okay, I get that, but if it's in a statement of facts, then why don't you tell me what the photographs that weren't a part of her deposition demonstrated or depicted? You just simply say they're not the same.
Your Honor, you're correct. They're not only not the same, but
so
they
why
also
don't you tell me what they show?
I don't know what they show, Your Honor. I apologize that I don't know that. I wasn't there.
Firm your trial counsel was. Seems to me you could have done a better job here in telling us why it's different and why it's prejudicial.
Your Honor, it's prejudicial because of, as explained in the case of Spinner versus Wayner, the movement, which is the fourth DCA case, the movement, or excuse me, the non-movement has a right to believe that the trial court will not consider evidence that does not comply with the statute. They made no suggestion in their motion that they were going to be relying on photographs. They made no, and the only evidence that they submitted with their motion was an aerial picture, which doesn't show anything, much less who owns the sidewalk.
Okay,
and,
so
and
the
a
aerial
lease.
sounds harmless. I'm not sure why you're arguing that's error.
Because
Sounds harmless.
because it's my understanding the judge relied on that as part of that was the argument that they relayed.
I
With
can't tell
respect.
from the order that he did.
Yet the summary judgment specifically says, their motion says on page 128,
No, I'm looking at the order. Their motion, they rely on whatever they rely. But the
I think
order from the judge doesn't tell me what emphasis he or she put upon that.
I think that if they're, well, with respect to, I think that the stipulation at the end certainly says that the judge relied on the lease, and the lease itself was in the same bucket as the aerial. It was an unauthenticated document that was just attached to their motion. And that's at paragraph 9 on page 231. The judge also, excuse me, he also relied on Ms. Gass's deposition, which was not properly, which was not filed 20 days in advance of the hearing. And in and of itself, which as this court recognized in Berizzo versus Bank of New York, that rule 1.510C at least the former rule, requires all evidence to be presented 20 days in advance of the summary judgment. And although I do concede that Ms. Gass did file the deposition, that's irrelevant, Your Honor. The trial court still couldn't consider it for two reasons. One, it was filed 7 days prior to the hearing, not 20 days, which the city did object to both in the motion, in its response, and at the hearing, that the court could not consider that. And two, the city, as I pointed out a minute ago, under Spinner versus Wayner, the city has a right to believe that the judge will not consider a non-compliant motion, specifically
Are you saying the email to your firm or the firm that tried it below, indicating clearly in the email 2 months prior to the hearing that we're going to use the deposition in the summary judgment hearing, is inadequate notice?
It does not comply with the statute, or excuse me, with the rule.
You need to say within your summary judgment, we're going to use that deposition that we told you about 2 months ago.
Respectfully, no, you have to file the deposition. What happened here, as I understand it, and candidly, opposing counsel and I were discussing this after the fact, and that's why we tried to give a full behind the scenes picture, was, as I understand it, there was a snafu in her trial counsel's department. They filed a notice of deposition through the portal, but it didn't actually attach or otherwise file those depositions. It just said notice of deposition. And that's what my trial counsel received and relied on. And that's why she raised the objection in in her motion, or excuse me, in her response. And but as pointed out by opposing counsel, they filed a separate sort of email, and it was sort of, this was the concept of when we had a hybrid system where the portal wasn't automatically, this wasn't at that time, but I think they're still relying on that hybrid system where they rely on the portal, they file, it gets served, and then they automatically send a separate email. Some attorneys do that. And here in the separate email, they included a copy of the deposition, but that deposition was never filed 20 days before the hearing.
Well, did the city and/or Ms. Gass rely upon that deposition in making arguments to the court?
We did, but we didn't waive our objection in doing that. I don't think
How
that
so? How so? How can you use the deposition to affirmatively state something to the court and yet argue as to its admissibility?
Your Honor, I think that with respect, I believe that's quite permissible if you're arguing that, hey, this is not admissible. But even if it were admissible as an alternative argument, one can make alternative arguments both in pleadings and at hearings. That it's.
Well, where was the motion to strike the deposition for failure to follow 1.510 filing procedure? You didn't do
No.
that. You didn't file a motion to continue for discovery. Plus your agreed upon statement doesn't tell me what discovery was outstanding, what deposition, what request for production, request for admissions, interrogs, nothing. Just says we need more discovery.
With respect, Your Honor, the rule does not require a separate motion to strike. The motion, the response itself argued and raised the objections with regarding their entire summary judgment evidence with the just simply attaching in the fact that the deposition was filed. There's no cases that state that that a motion to strike is required, and the rule didn't require it. And as far as the request for more time to discovery, yes, there was no formal motion filed, but the rule doesn't require a formal motion. In fact, this court's decision in Brandoir, I think is how you pronounce that, not 657.
Mr. Donovan, doesn't the interpretation offered by the case law basically say you would be entitled to a continuance if there is some prejudice to go forward because there hasn't been adequate time for discovery?
I'm just trying to think about what your question is in the context of the case.
Your client was in this case from the beginning.
Correct.
So the summary judgment motion and hearing took place how long after the case was filed?
5 months after the CHOPS was added.
Your client was brought into the case at the very inception, correct?
Yes, Your Honor.
Okay, so how much time did your client have from the date suit was filed until the date of the hearing to conduct discovery?
Well, discovery had been ongoing, and you're right, we had been in the case much longer. I don't remember the exact time period of when it was filed.
What in the stipulated statement reflects an argument that your client is prejudiced in some meaningful way because it has not had a full opportunity to conduct discovery?
Well, it's not only in the stipulation does state it at page 231 that limited discovery has occurred in this case, therefore summary judgment at this time is premature. But arguments that are raised in motions and responses are equally adequate to preserve. One doesn't have to just advance these.
But we don't know what happened at the hearing if the court said, okay, you've asked for a continuance or you're now asking Ori Tennis for a continuance. How are you prejudiced? And as far as we can tell from this record, your client didn't have a response. Now, we don't know that because we don't have a transcript. But let me just say, you're at 4 minutes. I'm going to give you another minute to conclude this portion of your argument, and then you'll have your 5 minutes of rebuttal.
Okay, thank you, Your Honor. I just conclude it by stating, even if this court were to consider the evidence in and of itself does not irrefutably show that CHOPS owed no duty as to the pavers, which is the real issue here. Certainly, even if you considered all of that evidence, even if you considered the lease, the aerial and the deposition, which the deposition doesn't show anything, they certainly don't irrefutably prove that they lacked any duty, both a duty to maintain or a duty to warn. I'll reserve the rest for rebuttal.
Very good. Thank you, Mr. Donovan. And Ms. Degnan, you'll have a couple extra minutes as well.
Thank you, Your Honor. Good morning. May it please the court. Sharon Degnan here on behalf of Kubicki Draper, representing the Appalachia Chop City Grill. We're here today asking the court to affirm the final summary judgment entered in favor of my client, Chop City Grill. And as laid out in our brief, it's our position that the premises liability theory that the plaintiff and the city, both below and on appeal, are trying to assert are legally unsound. And there's both a lot of substantive issues raised in this case, and there's a lot of procedural issues raised.
Ms. Degnan, let me ask what I think, at least for me, is a key question. Ms. Gass is uncertain as to exactly where she fell, but she fell in front of CHOPS. We know that. Her deposition is clear. There doesn't seem to be any real dispute about that. The sidewalk seems to be a city sidewalk, but that isn't clearly established, is it?
Well, I think it is clearly established. I am going to say I think it perhaps could have been more clearly established, but I think it is clearly established. And I think the reason why is because—
In fact, let me interrupt because I do want to ask one other question. In her deposition, to the extent that we are going to consider it, I think she testified that the manager of CHOPS was right there, came out, got on the phone, and saw her on the ground. I don't know that the record tells us why the manager's affidavit or other affidavits are not in the record saying, here's where our property line ends, here's where she fell, or giving some explanation. And obviously I don't want you to go outside the record, but I am trying to figure out exactly what CHOPS was relying on to establish that she fell on property other than that being maintained by CHOPS.
Right, it was relying on several things. It was relying on the testimony, certainly, of Ms. Gass. And I think it's true that when you read her deposition and where she says she fell, it's clear that it was in a portion that it abutted Chop City from the perspective it was in front of it. But she was very clear that she basically stepped up from the street onto the curb and fell in that area. And the photos that are in the deposition, when you look at those photos, it's very clear where she fell. So I agree with you, Your Honor, that she did say she wasn't exactly sure, but in relation to the street and the curb and where she was very clear. And the photos, I think, are what provides evidence that it was a city street. And I think the other, I wouldn't call it.
One of the things that your brief didn't address, and I don't recall if Mr. Donovan's brief addressed it, but there's case law that reflects very clearly, even if a city or a municipality owns property, if other people are exercising control over that property, then there potentially is joint liability, or it may be liability of the one who is exercising some control. So what establishes that, as Mr. Donovan argues, that these pavers were or were not installed by the city or were or were not installed by CHOPS? What is there that establishes that CHOPS has no obligation in relation to the pavers that she fell on?
Well, and I think my brief did address it on some level. I agree with you. If I'm familiar with the line of case law Your Honor is talking about, there's a Central Hardware case, and there's those cases that talk about the fact that if the abutting property owner does something like puts like a rug, like Central Hardware, it was on a public sidewalk, but there was a rug that was placed on the public sidewalk. And what the court said is that, well, because you placed that rug there, you would have a duty to maintain it. And they talk about, like, if you were to do something to the sidewalk that you did that, then you would have an obligation to maintain it. But that's not what this is. And I think when this isn't a situation where Ms. Gass tripped over a table or a chair or something that CHOPS placed on the sidewalk. So because of that, it's our position that this is somebody falling on the sidewalk. And the case law.
Do we know as a matter of evidence that the city or the county or someone other than CHOPS putting these pavers, or are we making an assumption that the pavers were put in by the city or county or somebody other than CHOPS?
Well, and I don't even know that it matters who put it in, because I think if you look at the municipal
if CHOPS wait a minute, if CHOPS put the pavers in, wouldn't CHOPS at least facially seem to have some duty to maintain those pavers?
Well, no, not if it's done through the municipal code. And I'm not saying they did or they didn't. And I agree with you. I don't think the record's clear on that. But I think the point is that it's a public sidewalk, and the case law, because of that, it's the city's burden and duty to maintain that as a matter of law. And the cases are very clear that
your position is that if CHOPS was permitted to put those pavers in, that its responsibility ends at that point in time, once they put it in, whether they put them in well or badly, whether the underlayment was adequately compacted to keep the pavers in place. That's not CHOPS' responsibility by any stretch of the imagination, is what you're telling me.
Well, Judge, I think it becomes an issue of when it was done, and there could be slabbing issues. I think but the issue is when you read the Naples Municipal Code, and there may have been a reason that a property owner would have to do certain things when Fifth Avenue South came into existence. But I don't think that's the issue.
If the property owner did it poorly, does that mean the city has the obligation to correct the poor work of the person who did the work?
Yes, I think the case law is clear that the city has the obligation to maintain the sidewalks. And when you read cases like Shupak and Del Rio, they're very clear that that duty is on the municipality. And the cases go so far as to say, unless there's an ordinance provision that specifically creates a private cause of action for a person that's injured on a public sidewalk, yes, that's how I read the cases.
So a
I think
public
that's what-
sidewalk, and I really don't want to belabor this too much longer, but a public sidewalk that a private entity modifies, for example, by putting pavers or planters or other things, that the party who made those modifications has no liability whatsoever. That's your position?
No, I think if they put a planter, if they did something,
If
I
they,
think that
okay,
would-
let's narrow it to what we have here. If CHOPS put pavers in on the public sidewalk with the permission of the city, is it your position that they no longer have any responsibility for what happens with those pavers?
if we're gonna make a distinction between the pavers and the sidewalk, I'd submit, Your Honor, that is the sidewalk. And I don't think the record is clear necessarily who put them in, but I think at the end of the day, that's the sidewalk. I mean, to argue that.
One other question, and then I'll have you move on. And I don't want to, again, take all your time, but why should we not reverse simply on the basis that the motion and the filings did not comply with the rule of civil procedure?
I'm sorry, the motion and the filings.
Yeah.
Your Honor, because our position is that the motion and the filings did comply with the version of Rule 1.510C that was in effect at the time. Because when you read the rule, what it actually states is that the movement must serve the motion at least 20 days before the time fixed for the hearing and must also serve at that time a copy of any summary judgment evidence on which the movement relies that has not already been filed with the court. So certainly with respect to the deposition. And I think that really is the most important piece of evidence here. We did serve the deposition on the opposing parties 20 days before the hearing. And Judge Sleet actually discussed the email that was sent. And that's actually what happened here. A notice of filing was served on, I want to say April 17th. And then the hearing was June 26th. So 2 months before, a notice of filing was filed in the court file. For whatever reason, I can't tell you why. The actual depositions were not attached to what was filed in the court file. However, in the email, the 3 depositions were actually served on both plaintiff and the city. So our position is we did comply with Rule 1.510C. And I know that the city has been relying on Verizon to argue we didn't. And I think Verizon, the facts are distinguishable there, Your Honor, because in Verizon, the note that was being relied on, the original note, was not served or filed within 20 days. And I think that's a critical distinction.
But do you agree the deposition does not, excuse me, the deposition and Ms. Gass's knowledge of the area does not establish who had the responsibility to maintain and control the paver area?
I think it establishes that it's a public sidewalk when you look at where she fell. And I think when you look at the sections of the Naples Municipal Code, which plaintiff relied on and discussed in their response to the motion for summary judgment, to argue why they thought that there could potentially be a duty for CHOPS as an abutting property owner to have a duty to miss gas. And I think legally what they were saying is wrong, but I think when you look at the sections of the Naples Municipal Code that talks about an abutting property owner has to obtain a permit and do certain things to be permitted to put tables and have outdoor dining on the public sidewalk, it establishes that this was a public sidewalk. So again, I mean, I think really what this case comes down to on the merits substantively is that if this court would basically have to be finding that anytime a pedestrian is walking down a public sidewalk and falls on the sidewalk, that there's a duty potentially owed to the pedestrian. And that's contrary to all of the law in this state. As I said, Shupak, Del Rio, all the cases that we cited, the law is absolutely the opposite. So again, if this was a situation where she fell on a table that was placed or a chair that we placed there, yes, I would agree that under that Central Hardware case, that could create a duty on the part of CHOPS. But without it, I mean, the case law is very, very clear that there is no duty here owed by the abutting property owner. It's the city that is owed the duty. So, in light of that, that's how I understand what the trial court ruled. And again, I agree,
Well, the trial court did not, at least according to the stipulated statement, the trial court didn't address any ordinances, any agreements and the like, other than based on the lease agreement, the CHOPS is not responsible for the pavers.
well, right. Well, that may be true. I mean, but certainly.
Is it not true or is it true? I mean,
What was
I'm
it?
looking at the order right now.
It's not addressed in the order. That's true, Your Honor, 100%. But I mean, I was just saying, I agree with you. Without a transcript of the hearing, it makes it more difficult. But what the court ultimately found from the order and from what was in the statement of evidence, the court found that CHOPS didn't have control of that. I think he was, because it's a public sidewalk. And I mean, ultimately, I don't think that can really be denied. And I think that's part of the issue here is that, I mean, it's really a legal issue. The issue is, does an abutting property owner have a duty to a person walking down the sidewalk? And the answer
isn't the question, does an abutting property owner who may exercise or might have exercised some control over the sidewalk have any duty to the public?
But I think Shupak answers that, and Del Rio, both those cases say, unless the ordinance specifically states that there is a private cause of action had by the person that's injured, it's the city's duty or the municipality's duty to maintain the sidewalk. The exception being, like, if they added, like I said, if it was a table and chair, I don't think you can't take that position. If
So
there was a mat.
the case from our court of Cook versus Bay Area Renaissance Festival says a party who assumes control over the premises in question, no matter under what guise, assumes also the duty to keep them in repair. And that's a quote from another case out of the first DCA. And then there's deposition testimony in the Bay Area case that Bay Area was using an adjacent lot for overflow parking. And so it was exercising control. So
But the issue there, and again, I think that was the case, wasn't it, where people were being asked, there was some kind of premises liability theory where somebody they had to do something. I mean, here, this is just somebody walking down the street. There is no control being exercised. And I think, both the city and the plaintiff has relied on general premises liability cases, which are not these municipality cases. And I think that's the distinction here, because this isn't a situation where she was walking into our restaurant. And the truth is, when I read those cases, the municipality cases, even if you read Canton's and Bay, it doesn't matter. It's their burden to maintain the sidewalk. And I think Shupak and Del Rio are very clear that unless an ordinance specifically creates a private cause of action to allow a party injured on a public sidewalk to bring a cause of action against the abutting property owner, there is no such cause of action.
I guess we'll agree to disagree, because if a private party exercises control and the city doesn't stop that, I think they potentially have liability, but we'll just agree to disagree on that.
Fair enough, Your Honor. Again, I don't know that I can't disagree with you that the evidence hasn't been fleshed out in terms of who put in the papers, but And again, our position is that the trial court correctly entered summary judgment in this case. And there's been a lot of procedural and substantive things that confuse it. But at the end of the day, we believe the court's ruling was correct.
Is there any dispute as to whether this entire sidewalk abutting that road where Miss Gass's friend had dropped her off was comprised of pavers in front of every business?
The evidence.
Or did Chops just have pavers and everybody else had concrete?
I don't believe that's the case, but I don't think the record answers that. So I don't want to tell you something that's not correct, Your Honor. If there's no other questions for me, we'd ask the court to affirm.
Very good. Thank you, Ms. Dignan. Mr. Donovan, you've got your 5 minutes for rebuttal.
Thank you, Your Honor. 3 points. The first is, and it kind of delves into Judge Sleet's question right there towards the end, which is that candidly, the record doesn't know. I'm trying to think to myself, I've been down there, I can't even think of it, what it is, but I don't know whether or not there's pavers all over the place or just pavers in front of Chops Grill. But what I can suggest is that Gass's deposition does not state that this is owned by Chops Grill or that this is owned by the city. In fact, it's not even sure. She wouldn't be competent to say who owned the area that she fell. She doesn't even know where she specifically fell. And rather, what's being done here is that Chops is drawing the inference that because it's a sidewalk, it's a public sidewalk. And all inferences are supposed to favor the non-movement. And I don't think that's an inference that this court can rely on to affirm summary judgment. Rather, it needs to be reversed. They may ultimately prevail on that. I don't know, but they can't win on summary judgment on Ms. Gass's deposition alone. Second, as Judge Silberman, I think, was getting at, and the point that he raised at some point in the middle of the oral argument, and we did advance this in our reply, was that there can be joint tortfeasors even if the city has a non-delegable duty over a public sidewalk. Even if we assume this is a public sidewalk, there can be joint tortfeasors if somebody else or another business, et cetera, is exerting some sort of control or possession over it. There is simply no difference between the cases like the Canton's case, where it involved the trip and fall of a mat in front of the hotel, or the Center Hardware case. I think it involved a table or something. There's simply no difference between Chops or the Chops' landlord putting a table or a mat and putting pavers on a sidewalk. I mean, if they're the ones that put the pavers there and they had a duty to maintain it, then again, this court must reverse because they haven't disproved that they had no involvement in the pavers. And finally, a point that I just want to point out, that all we've talked about today is the duty to maintain. We haven't talked about the duty to warn, which was thoroughly addressed in the briefs and has never been refuted by Chops Grill, and the duty to warn of constructive or actual known defects exists regardless of whether or not
I didn't see anything in Ms. Gass's deposition where she described anything that needed to be warned about. Her shoe came off and she fell. She never described a defective paver. She just simply said they had pavers and my shoe came off. I'm trying to figure out, how do you articulate a warning for that?
Well, it's my understanding that the pleading was that it was an uneven paver, that it had somehow, that's what caused her to trip. In terms of,
she never said that, but.
Well, with respect, Your Honor, and I guess this kind of delves into an additional point, and that is that the actual portion of the deposition that was cited in the motion doesn't really say anything. And that's really the only portion that was advanced at the summary judgment stage. They've advanced a bunch of additional areas of the deposition. I don't think it's proper to be considered on appeal because the trial judge didn't necessarily rely on that because that wasn't what was advanced in the written motion. Therefore, with respect, Your Honor, I don't think they've proven irrefutably under the old standard that they are entitled to summary judgment as a matter of law on duty, and this court should reverse and remand for further proceedings.
Mr. Donovan, I just want to clarify one point before we finish.
Certainly.
The complaint alleged duty to maintain, not a duty to warn, correct?
You know, Your Honor, I don't know the answer to that right off the top of my head. Would you mind if I let Mr. Lee respond to that question?
Mr. Lee, I'm looking at the complaint. It seems to be phrased for duty to maintain.
Yes, Your Honor. I'm actually looking at it. I'm trying to find it myself. Give me just 1 minute to do that. I know that there was I believe there was allegations of a dangerous condition, but I'm trying to.
Paragraph 8, negligently and or incorrectly installed, making them safe, defective, dangerous, failed to reasonably maintain. I don't see anywhere else that there's any allegation regarding a failure to warn.
Your Honor, what I would argue regarding that is that paragraph 8 is what you're talking about. It actually, in my mind, would include both.
Okay.
The negligent maintaining, and then, but then there's also a defective condition.
All right. Well, thank you. We'll review the complaint on our own, but it says what it says. That will conclude.
That's true, Your Honor.
Thank you both. That will conclude this oral argument. Ms. Degnan, Mr. Lee, Mr. Donovan, thank you very much. The next case is HCA Health versus Brett.